Alrighty, we're gonna try this again. I wish I could show you how much it says we have, a great connection and that our stream health is good. It is just me. Technology does not like me. I've restarted everything, literally everything. Let's just.
Come on up, Ms. Harrison, up to the witness stand, please. Raise your right hand. Excuse me. Do you solemnly swear or affirm under penalty of perjury that you're about to give the truth, the whole truth, and nothing but the truth?
Yes, I do.
Have a seat.
Good morning, Ms. Harrison.
Morning.
Could you please start by introducing yourself to the jury by your full name?
Amber Michelle Harrison.
And how do you spell your last name for the court reporter?
Harrison.
Ms. Harrison, where are you from?
Right now I'm living in Biloxi, Mississippi.
Where are you originally from?
From Colorado and California.
Okay. Was there a period of time that you lived in the Durango area?
Yes, I did, from 2006 to 2020.
Okay. And what did you do for work in the time that you were here in the Durango area?
I was an attorney and a judge.
And what years were you an attorney and what years were you a judge?
2006, I'm still a licensed attorney in the state of Colorado, and I was a judge from 2016 to 2020.
Okay. And what do you do in Mississippi now?
I work at a spa as a concierge.
Is that a little more relaxing than being an
Very
attorney?
much so.
Where'd you go to law school?
I went to law school at Thomas Jefferson School of Law in San Diego, California.
And what was your focus in law when you were a practicing attorney?
My whole career in the legal industry from 1996 forward is family law, domestic.
So you said you came to the Durango area around 2006. When did you know the Redwine family?
I met Ms. Hall in 2008.
In what context did you meet Ms. Hall?
She was assigned to me by my my firm as a client.
In what type of litigation?
Divorce.
At the time, what was going on with the case at the time, just generally speaking?
She and Mr. Redwine had obtained a legal separation through another attorney previous to my involvement. So at that time, it was my job to help her get a dissolution of marriage and divide the remaining marital assets that had not been divided in the legal separation.
Breaking that down, is that basically dividing a property?
Yes, property, debts.
Setting that aside, what was the custody situation at the time that you met Ms. Hall?
At the beginning of the case, the parties stipulated to parental responsibilities for Dylan as 50-50. The parties were going to share equally.
When you say at the start of the case, what time frame are you referring to?
2008, probably one of the first hearings, if not the second hearing we went to.
Okay. And then did you handle the formal divorce in 2009 as well?
Yes, I did.
And then did you stay on representing Ms. Hall through a custody case as well?
Yes, I did. Still the attorney of record on that case.
So going through the split custody years, were those split custody years where Dylan was going to both houses equally, or what was it really?
No, in the beginning, I think he was, Mr. Redwine was exercising his parenting time somewhat. It became less and less over the years to the point that he was not exercising parenting time, requiring Ms. Hall to take Dylan with her when she had to travel for work and would miss school.
And was this in the time frame prior to the formal divorce or after the formal divorce?
After the formal divorce. So when the decree was issued in 2009, this was after.
And then was this before or after the custody was actually an issue in the case?
Okay, I don't understand the question.
Yes. Let me ask a different question. Was there a point in time when there was a motion to relocate?
Yes.
And the time frame, was that July of 2012?
Yes, sir.
So between 2009 and 2012, is that the time frame you're talking about right now?
Correct.
Let's fast forward to that September of 2012. Were you involved in that litigation yourself?
Yes, I was.
Did the motion to relocate, what was that?
It was a request by Ms. Hall to relocate with Dylan to.
Your Honor, this is hearsay. I mean, to have the lawyer discussing what client requested and
is she discussing what the proceeding was about?
Right, but that necessitates the client attorney.
Didn't she probably draft the motion?
Yes, but she wouldn't have been able to do so without hearing statements from her client. And so what we're talking about here is things that she was instructed to do or requested to do or otherwise did because of the attorney-client relationship, which would require client describing to you, here's what I want you to do, and then that becomes a motion to relocate. So the lawyer would need to learn from client
You're
that
stretching here. The attorney can file a motion to relocate, and that is not hearsay. And to relocate to Colorado Springs, she can know what she filed, what fine remarks to what she did. If there's a reason to go further, we'll see.
Yes, Your Honor. So, Ms. Harrison, did you file a motion to relocate on behalf of Ms. Hall to Colorado Springs?
Yes, I did.
What did that motion ask the court to do?
It asked the court for...
If I may, objection. This requires description of what client wanted. Lawyers don't just file motions to relocate without the hearsay from client that says, this is why I want you to file it. That's exactly what the prosecution's going to do.
You're overruled. She's saying what she did. We all understand that's probably what Ms. Hall wanted. This is not hearsay. This is what she did. This is what the motion stated. You're overruled. Go ahead.
Thank you, Your Honor. Ms. Harrison, what did the motion ask the court to do?
Motion requested Ms. Hall be granted permission to relocate with the minor child, Dylan, to Colorado Springs.
Did this bring about a need for a new, more formal custody agreement?
Yes, it did.
So even though Ms. Hall, as you described it, had custody basically informally, did you file motions and were motions filed in terms
Love
of
this,
formal
Judge.
custody at that point?
Yes, we filed the motion to relocate and the motion for Ms. Redwine to be the primary custodial parent with visitation to Ms. Hall, to have primary custodial parenting rights, and for Mr. Redwine to have reasonable visitation.
Did you meet with Dylan Redwine as part of that process?
Yes, I did.
And before I talk about that custody hearing, let me talk about your relationship over the years. Did you get to know Dylan?
Yes, I did.
How did you get to know Dylan?
After Ms. Hall and I thought her case was over, because I don't mix friendship and my attorney-client relationship. When we thought that was over, we decided it was okay for us to develop a friendship. Through that friendship, I had the opportunity to meet Dylan, play board games with him, watched movies with him, hung out with him.
When did you become, when did it segue from the more professional relationship over to a personal friendship?
After the decree was issued in 2009, Ms. Hall and I started a friendship, but it was some time later before I actually went over to her house and met Dylan on a personal level.
Did Dylan talk to you individually at times?
Yeah, we talked a lot over the years, but never talked about Mr. Redwine.
And then after you developed this personal relationship, then it sounds like in 2012, more court litigation came up.
Yes, at which time Dylan specifically requested to speak with me about his testimony to Judge Dickinson.
Okay. And did Dylan tell you his thoughts on where he wanted to live?
Yes, he did.
And what did he tell you?
He wanted to live with his mother.
Did he tell you did you watch the relationship firsthand between Dylan and Mark Redwine over the years at all?
I never saw Mark or Mr. Redwine over the years. I do know that over the years the relationship deteriorated because it was clear that Dylan didn't want to go visit with his father, just based on things that I had seen.
Did he ever voice concerns to you about going to see his father closer to the time of the Thanksgiving visit?
Yes, when we met before the September hearing on the motion to relocate.
What were Dylan's concerns?
He was not comfortable around his father. He disclosed to me that he had seen the pictures that creeped him out and made him feel very uncomfortable.
Then when the hearing occurred, how did that hearing work? For example, did Dylan get input?
Because of his age, we filed a motion for him to be able to testify or to be interviewed by the judge in chambers. That request was granted. So during the hearing, Dylan was taken into chambers by Judge Dickinson and was interviewed in private by Judge Dickinson.
Okay. And then is that the purpose of that interview, to get Dylan's input on where he wants to live?
Yes, sir.
And then also you mentioned the pictures. Are those I refer to them as compromising personal photographs. Is those the pictures?
Yes, sir.
Did he describe them in detail to you, however?
No, he didn't.
Okay. What did he tell you about them or them upsetting him? What did he?
He told me they were creepy pictures, and he told me he was creeped out by it, and he didn't want to visit with his father. I personally have never seen the pictures, so but I'd heard about them, so I knew what they were.
And then going into going into the hearing itself, What did the court ultimately decide after hearing from Dylan and hearing from the parties with results of custody, with regard to custody?
The court granted Ms. Hall's motion to relocate, meaning that Dylan would be residing with her primarily up in Colorado Springs, and Mr. Redwine was granted visitation rights.
Was there a specific visit that he was granted at the time of that hearing?
I believe it was a Thanksgiving visit.
And that was a part of that same order that had given custody primarily to Ms. Hall?
Yes, sir.
Was that in fact a court order?
Yes, it was.
Now, I want to talk specifically about that visit. Did you talk with Dylan after the hearing about whether he wanted to go on that visit to see his father for Thanksgiving?
I do recall speaking to Ms. Hall. I believe Dylan was in the background, but I did not speak to Dylan directly.
Were you asked legal advice?
Yes, I was.
Were you asked about whether Dylan did or did not have to go on that trip?
Yes, I was.
What were you asked?
I was asked if there was...
Objection, hearsay.
Wasn't this testified to yesterday? And this being asked so she can explain what the advice was? And why is that hearsay? You ask a question, is that for the truth of the matter asserted? I don't think it is.
This out of the court statement, were you asked this question?
Out of the court statement offered for the truth of the matter asserted. This is the question, were you asked? So, the question being asked, so what's being asserted? So why is it hearsay?
I don't remember what the question being asked is, but the premise of the question is the truth of the matter being asserted, and that makes the question and the content and subject matter of it hearsay.
No, it doesn't. Have a seat.
Ms. Harrison, what were you asked about that trip?
I was asked if there was any options to putting Dylan on.
Anytime they're going to start talking about how much Dylan didn't want to go, how much everybody in Dylan's life knew that he didn't want to go. Every time we're going to talk about these, what they say, compromising personal photos, defense is going to object. Defense doesn't want any of this emotional, heartstring pulling testimony to come out, because that's what the jurors are going to latch onto. They are going to latch onto that emotion. They are parents. They are children of, who have parents. I mean, they're adults, but, they know what it was like. And to be, for any of the moms that are, or dads that are on this jury panel, for them to sit there and think about, what if my child was standing in front of me and saying, I don't want to go to my dad's. Like, look, this is what it's like. This is the problem. This is why I don't want to go. That pulls on your heartstrings. So defense is going to object every single dang time.
Who asked you?
Ms. Hall.
Is that on behalf of Ms. Hall and Dylan Redwine asking you legal advice?
That
Yes.
could probably be part of that, could be hearsay. So just go ahead and ask your next question.
Okay. So, based on the question you were asked, did you have to give Ms. Hall a response as to whether or not Dylan had to get on that airplane?
I did give her legal advice.
What did you tell her? Take your time, ma'am, and there are tissues to the left as well.
I told her that she had to put Dylan on the plane or she would be charged with contempt of court.
Are you okay to proceed, or do you need a second? Ms. Harrison, how did you find out that Dylan Redwine was missing?
I received a phone call from Elaine.
When did you receive that phone call?
The day after Dylan arrived in Durango.
And what did you, I don't need the specifics of what you were told, but you were generally informed that Dylan was missing?
Yes, I was.
When Ms. Hall called you, was that a call about anything related?
That is so freaking rough. I just want to stop right there. And Amber Harrison, it is not your fault. You do not have any blame or anything in this. I know you feel some sort of way about it. But, the reality of the situation is this was all on Mark and Mark's choices. And, I can't imagine how she feels, as a officer of the court, basically. She told the truth. She said, and part of me just kind of wishes Elaine would have kept him home. Man, he might still be here.
To a court case, or was that a personal call about Dylan?
She called me as a friend.
What did she call you about specifically?
She needed to inform me as to what was going on, and she needed to know if she had a place to stay in Durango.
And did she have a place to stay in Durango?
Yes, she did.
With whom?
Me?
What did you do after you received that phone call?
If I'm not mistaken, I called his attorney.
And why did you do that?
Most likely because I couldn't call Mark, and I wanted to know if she knew any information about where Dylan was.
At that point in time, was the goal of everyone to find information about where Dylan was?
Objection as to how she would know everybody's goal.
Understood, Your Honor. Ms. Harrison, based on the people that you were interacting with, was it the goal of the people you were interacting with to
Yes,
find Dylan?
it was.
What did Elaine Hall do?
Pardon me?
What did Elaine Hall do after she had notified you that Dylan was missing?
I instructed her to contact the Plata County Sheriff's Office and report Dylan as a missing person.
Prior to using BetterHelp, I don't think that I would have considered online therapy.
Considering therapy? Try BetterHelp.
And it was only in that first
She did.
And then did she travel?
Yeah, she immediately got in the car and drove to Durango.
Did you see her when she arrived?
Yes, I did.
And did she stay with you?
Yes, she did.
And who else arrived with her?
I believe at that time it was Mr. Hall.
Corey Redwine there as well?
Yeah, he probably came that same night.
Did you know all of them?
Yes, I did.
And were they all welcome to stay with you?
Yes, they were, and they did.
What was it like in the days that followed in terms of your involvement in trying to find Dylan?
Every day I watched everybody that was staying at my house leave to go on searches, to search for Dylan in Bayfield and everywhere else that they thought he might be.
Did you stay involved over the course of the months that followed?
I did.
How did you hear about Dylan's death?
I can't recall who told me that they found remains. It was most likely Elaine.
Were you still in the area at the time?
I was.
Do you see Mark Redwine in the courtroom here today?
Yes, I do.
Where is he sitting, and what's something that he's wearing for the record?
He is sitting all the way to my left, and he is wearing a gray suit with a white shirt and glasses.
I would ask that the record reflect the witnesses indicating the defendant.
It can.
Thank you, ma'am.
Thank you.
Oh, yeah, just hold on just a second. Go ahead. Yeah. How much? A little more. A little more. Just a touch more. A little more. We need a better picture of you. You don't. Whenever you're ready, Mr. Murray.
Thank you, Your Honor. Thank you. Well, there's a lot of materials.
I have trouble finding it too, I understand.
Appreciate the moment to look through it. Thank you. Good morning.
Good morning.
Just to clarify a couple of things you were discussing on direct, you recommended that Ms. Hall, now Ms. Hatfield, call law enforcement, and she called you on November 19th.
Yes, I did.
You didn't call the sheriff's office, right?
I don't believe so. I may have.
And your call was to the lawyer, right?
Correct.
And you mentioned that you do not carry on friendships with clients, correct?
That is my policy.
And Ms. Elaine Hall is your friend,
Yes, she is.
and she is your client.
Yes, she is.
You're currently attorney of record, right?
Yes, I am.
And you guys are close enough that you travel together, is that fair?
I'm not sure when you're speaking about.
trip to South Dakota, Mount Rushmore?
Yes, sir, we recently did take a trip there.
May I approach?
You may.
Objection if this exhibit's in agreement with your.
Okay. And what number is that, Mr. Marine?
1163. I'm going to hold off on that for a second. I think that my ability to get that up on the screen is going to take a moment. So,
All right.
if I could reach, get back there. In order to provide the information that you're giving today and that you've given on other occasions in this case, Ms. Hall had to waive attorney-client privilege, right?
Yes, I believe so.
And you would agree as an attorney
And don't forget, guys, the link to all of these exhibits is down in the description box below. It is the Colorado Judicial Court System. That link should take you straight to the case of Mark Redwine, but their court system online is actually really pretty cool, and they list out the cases of interest, etc. You can see it all right there. Just letting you know.
former judge for the Municipal Court of Ignacio, that violating attorney-client privilege has very serious consequences for a lawyer.
And not if it's been waived by the client.
Sure. But in the absence of that waiver, it's extremely serious, right?
Yes, it is.
Presumptive disbarment.
Yes, it is.
It's an extremely important responsibility for a lawyer.
Yes, it is.
And the idea behind it is that information provided between client and attorney is confidential so that you can be provided the unvarnished truth.
Correct.
And you would agree with the principle underlying this rule for lawyers that a lawyer's responsibility to act as counsel is best served when clients speak freely and candidly with their attorney, right?
Yes, I do.
You encourage honest sharing with your clients, agreed?
Yes.
Doing so allows you to provide state-of-the-art representation.
Yes.
Advice you give is based on info that clients provide you, right?
Yes.
And in this case, the information provided to you by Ms. Hall was that she did not think Mr. Redwine would ever hurt Dylan Redwine, correct?
Correct.
So your entry of appearance in the domestic relations case, divorce case, was in 2008?
Correct.
And that was the divorce of Elaine and Mark Redwine, obviously.
Correct.
And you were working for another lawyer's law firm at the time.
I was working for Greenberg, Herringer, and Ward.
How much were clients charged per hour?
I don't recall what the prices were back then.
More than $100 an hour?
Yes, sir.
More than $200 an hour?
No, sir.
You continued working Ms. Redwine's case for since at least 2015, right?
Correct.
And also another important responsibility of counsel is to seek expeditious resolution of matters to include divorces, correct?
Section of relevance?
I'm not sure where you're going with this, Mr. Moran.
Established bias.
Well, we'll see. Go ahead.
You have a responsibility as counsel in the divorce matter to seek expeditious resolution of the Redwine divorce matter, correct?
As quickly as I can, absolutely.
You would agree that the divorce involved multiple lawyers and went on for more than 10 years.
I believe Mr. Redwine had multiple attorneys. Ms. Hall remained with me, and yes, litigation went on for a number of years.
And there was a lawyer that Ms. Hall had engaged prior to your representation, right?
For the legal separation, yes.
You spoke to Dylan before he met with Judge Dickinson, right?
Correct.
Do you recall the placard or description that was on podiums in Judge Dickinson's courtroom?
Section of relevance, huh?
Your Honor, as Your Honor will recall, Judge Dickinson...
You know, I don't remember that. Go ahead.
This may be something that I could seek judicial notice of. In his courtroom, there were things on the podium saying that the manner of his speech was not related to his reason and cognitive ability, that he had an issue that...
Did you need me to instruct the jury on that or not?
That would be great.
I'm sorry, Judge.
You don't know what we're talking about, I know.
No, and that
Okay.
may make it inappropriate for this to be admitted. But I have no idea what counsel's referring to.
I know you don't because you weren't here.
Seems irrelevant.
Well, I'm going to instruct the jury that Judge Dickinson, shortly before he retired, developed the condition, and I think I remember the right name for it, but I don't want to say it because I'm not sure that's correct. And it basically made it appear as though, well, it made him slur his words. It made him appear as if he was intoxicated, which he was not. He had full control of his faculties. He just had a difficult time enunciating his words, and it progressively got worse. And it eventually caused him to retire. So that's what you're referring to, correct, Mr. Moran?
Yes, Your Honor, thank you. So you spoke to Dylan before he met with Judge Dickinson, right?
Yes, I did.
And as is your practice, as is required of a licensed attorney, you would have encouraged him to be honest with the judge, correct?
I did instruct him to be honest with the judge.
You told Dylan what to expect with his meeting with the judge, correct?
I described the procedures, tried to reassure him that Judge Dickinson was another human being that he could feel comfortable speaking to.
And you described to Dylan what questions the judge might ask, right?
No, I did not.
You didn't prepare him for the topic of discussion that would be in chambers of Judge Dickinson?
No, I did not. The topic of discussion was entirely up to Dylan.
Okay. But you did prepare him to go back there and encourage him to be honest?
I encouraged him to be honest in whatever he needed to tell the judge to make sure that the judge understood how he felt.
Okay. So that would have been part of what you were describing for Dylan, and he would have been aware that it was a discussion about where he preferred to live, correct?
Dylan was old enough to know what we were going to court for. It was his request to testify or to speak to the judge. So I didn't have to tell Dylan what we were going to court for.
Do you recall that one issue of contention in the divorce was damage to the property on the Windmill Street address?
Yes, I do.
And you recall that Mr. Redwine, after the property became his, had to make repairs to the property so that it could be rented or sold?
Objection to relevance.
So what's the relevance to that?
This issue has come up with other witnesses, what was going on at the Windmill House. This is the witness who...
What's the relevance to the damage? I don't remember damage at the Windmill House. What's the relevance to that?
The beer bottles that were discussed earlier today in the text messages the prosecution introduced.
What's that got to do with damages at the Windmill House?
It informs what was going on in the Windmill House and how it's subject to litigation.
I'm going to sustain the objection.
Moving on. Do you recall that one of the issues that was in contention was claims by Mr. Redwine that Elaine Hall was alienating him from Dylan?
I believe that was one of Mr. Redwine's claims, yes.
And you advised Elaine Hall to get Dylan Redwine a cell phone, right?
I don't recall.
Would it refresh your recollection to take a look at the transcript?
Sure.
I'm going to ask the counsel to provide a little more context to that question.
In terms of deciding what relevance is? Or
Relevance, when, what context?
This would have been a hearing that occurred on September 21st, 2012. The relevance is that it gives more information about the alienation going on between the child and the parent. The relevance also includes that it informs around the issue related to your Honor's limiting instruction involving the photographs. Any further record I would ask to make it to bench.
Well, why don't you show her the document, and we'll see where we go.
Okay, hang on. I have to pause it for a second because I want to speak on what defense is trying to say. They're trying to say that there was alienation essentially put from Elaine, alienating Mark from Dylan. And I want to state, as a child of divorced parents, as a divorced parent with children, the children want to be in the presence of the person who makes them feel safe. They want to be in the presence of the person who provides for them, who knows them, who understands them, who cares about them mentally, physically, and emotionally. And just because you as a parent might feel like you do enough, or like you think about your kids enough, or care about their emotional, mental, physical needs, doesn't mean that you do. And it doesn't mean that these children accept it, right? Even at a young age, all the way clear up to, 17, 18 years old, they know who has their back. They know where they want to be. They, like I said, they know who's present. And it is very tough when there's a mom and a dad who are equal in that sense. That's when it gets hard. And I wish the court systems, I wish the judges, the attorneys would, and even that other parent, you know, I wish they would stop and think that, like, there's a reason why, right? Because if the child wanted to be there, and that was their, it was a huge dilemma between where I was going to go, because, oh my gosh, you know, I'm like half the time on my mom's lap and half the time on my dad's lap type of thing, right? If that's not there, and the child is specifically pushing towards being with one parent, a lot of times they want to say it's because they let them do what they want, or there's no structure, etc. That's usually not the case. Usually the child wants to be where the structure is. And so, you know, parents, if you're going through the split and your child doesn't want to be there, evaluate yourself. Evaluate your living situation, your presence, because that very well may be why your child doesn't want to be over there. It's not always the other parent, right? In this case, it wasn't Elaine saying, trust me, Elaine had a boyfriend. She was probably wanted some time to herself. She probably, in some ways, looked forward to when Dylan would go and visit his dad, right? It's not always the parent trying to keep the child from the other parent. Sometimes it's that parent and the way they parent that child, or lack thereof, that keeps the child away. Sorry, I had to speak on that.
Additional approach.
Yes.
Documented this, counsel?
Page 3,682 of discovery. Beg your pardon, it's 3,667. 3667, line 17. Beg your pardon, my site source is incorrect on that. I'll have to double back on that. Fair to say that there was litigation around Mr. Redwine's objection to Dylan being moved to Colorado Springs.
Yeah, yes, Mr. Redwine objected to the request to relocate.
Ms. Harrison, you would agree that it's important for lawyers to keep records.
It is.
Failing to maintain an appropriate record-keeping system is a violation of the rules of professional conduct that can result in the loss of your law license.
Yes, in general, yes.
It's also important to the billing process to document client meetings.
Yes.
And the lawyer has a professional obligation to document witness interviews.
Objection of relevance, Your Honor.
Same approach.
Well, do you have a response to the relevance?
I do. The relevance here is that there is no note that we've ever been provided with respect to descriptions of the pictures at issue by this lawyer who's noted that she was aware of them and had discussed it, and that's the case. That's never been provided to us, and I don't believe that there's any record of it, at least for this case.
She's not law enforcement.
She is a party that is regularly reported with respect to this matter.
She's not law enforcement, so therefore she's under no duty to provide anything to you. So I'm going to sustain the objection. I mean, I would hope that the prosecution is giving you everything they have.
We have, Your Honor.
And I don't know that they asked for everything. So what do you want to approach now again?
On that issue, this is just something that I think is wrought with possibilities that are problematic to discuss.
I really don't see where you're going with this, Mr. Moran. You need to move on.
You never included mention of the embarrassing pictures in a pleading, did you?
No, I do not think that the...
That's my question. Thank you. You did have an opportunity to review the recorded interaction between Judge Dickinson and Dylan, correct?
No, I did not.
That would have been available to you as attorney of record, correct?
Correct. However,
That's as much as I'm going to ask on that issue. In addition to being friends with Elaine Hall, you had Corey Redwine staying at your house sitting and dog sitting, right?
Mr. Corey Redwine stayed at my home during Dylan's disappearance while they were searching for his remains. If I'm not mistaken, they brought their dog. So did Ms. Hall.
I'm sure it's difficult being an attorney who's,
Ms. Harrison, have you watched the surveillance
questioning an
footage of Dylan
attorney.
Redwine in Walmart?
That's why he's
on November
keeping
18th,
her quiet.
2012?
No, I have not seen the surveillance video. I saw the pictures that were posted in the newspaper.
And you stated at a deposition that there were marks on Dylan's arms on the images from Walmart, right?
Didn't the witness just state she'd not observed it?
Right, and now he's trying to impeach her with something different that she said, so I think it's okay.
I don't know that I was ever deposed.
You recall that you were participating as a lawyer in depositions where you asked if Mr. Redwine could see the marks on Dylan's arms.
Asking a question is not evidence and it's not testimony, therefore I believe that you cannot ask this question, can you?
The rules of professional conduct require that you have a good faith basis to ask questions. And fishing like that,
Right, but we don't know what was going on in that deposition. We don't know what the issues were. I'm not going to let you ask it.
Have you ever seen scratches and otherwise marks on Dylan Redwine's arms in footage from around the time of his disappearance?
Again, I didn't watch the footage.
Following July 23, 2009 permanent orders hearing, Elaine was ordered to pay Mr. Redwine $72,514, right?
Objection of relevance.
Relevance to this?
It goes to bias of Ms. Hall and her close friend here.
All right. You can answer the question.
I don't recall the amount. I believe what you're speaking about is permanent orders that were issued following our permanent orders hearing in July of 2009. I think that's what you're asking about. Yes, she was ordered to pay an equalization payment, I believe.
Would it refresh your recollection what that equalization payment is if I showed you a copy of that permanent order?
Sure.
I'll refer here to line 34. It's page 23,241 of discovery. Mr. McCroach?
Yes.
Correct.
Does that refresh your recollection of the amount?
Yes.
The original amount was $72,514, correct?
Correct.
Payable by Elaine Hall to Mark Redwine, correct?
Correct.
After an appraisal on that house and some more litigation, that payment was reduced, right?
Correct.
To your knowledge, have those payments ever been satisfied?
Objection of relevance, Judge.
It goes to
Well,
bias in a really obvious way.
hold on a second. I interrupted you. Go ahead. I'm sorry. Go ahead.
If I might just say first, of course, it's an unpleasant thing to inquire after, but it's relevant to the bias. If someone is owed money, then the bias that could involve in that is obvious. It goes to the instruction on credibility that the jury is provided with respect to what the outcome of a case could mean to participants. The relevance here is obvious in my mind.
Mr. Johnson?
Your Honor, if the argument is that there's a bias over $7,000 when Ms. Hall's son is dead, I renew my relevance objection.
You know, it's for the jury to weigh whether or not that is sufficient to cause bias or not. It's not for me or for you to decide. So you can answer the question.
There was litigation back and forth over the marital estate.
Ma'am, hold on. The question is different. The question is, was that payment ever satisfied to your knowledge?
I don't think that I can answer that question the way you're asking it.
So the answer is no, it was not paid.
No, that's not what she said. You can answer. She's sworn to tell the truth, and if she needs to tell you more than you want to hear during the answer, she's entitled to. So why don't you answer his question?
We litigated back and forth over the value of the marital estate and how the equalization was going to be paid. The end result is that Mr. Redwine was awarded the windmill home, and that was I believe, the end of the property division once and for all.
At this point, I'm missing the person who's got this image to put on on the screen, so I'll just, by stipulation, ask for it to be admitted. It's Defendant's Exhibit 1163, an image of counsel.
I think you already stipulated to that, correct?
Yes, Your Honor. No objection.
Okay, that will be at some point. You have copies for the jury, though, correct? And the original for us?
If not at this exact moment, we will.
It'll be admitted. You'll get to see that at some point. So. Anything else, Mr. Moran?
No, thank you.
Any redirect?
Just very briefly, Your Honor. So, Ms. Harrison, you were asked a question about why you didn't reference the photos in the pleading, and you started to answer it, but you were stopped. Would you like to answer it?
Yes, I would.
Please answer that question.
As an attorney, I did not see the relevance of those photos. They would not indicate in and of themselves that Mr. Redwine was a bad parent.
And did you mentioned that you knew Dylan was going in there and you didn't tell him what to say, but you told him to be honest, right?
Correct. To tell all my clients, tell the truth. This is your story. It's not mine. If I tell you what to say, you're not going to be able to tell your story truthfully.
So you let Dylan go and tell the judge what he wanted to tell the judge?
Yes, I did.
Did the defendant know that Dylan was going to talk to the judge about who he wanted to live with?
I don't know what Mr. Redwine thought, but Mr. Redwine knew that Dylan was being interviewed by the judge.
Let me ask a different question. Did all the parties in the case know that the purpose of the interview with Judge Dickinson was so that Dylan could say where he wanted to live?
Just as Judge Dickinson would be assessing and taking into consideration Dylan's wishes.
And you talked a little bit, there was a lot of talk about property and things like that. But let me just orient you to a timeline. By the time of this custody hearing, had property disputes all been resolved?
I believe the property disputes were resolved. I think we had one remaining court issue as to reimbursing Mr. Redwine for the alleged damage at the windmill house.
Sure. The litigation over who got what property, had that been proceeding from 2009 up to 2012?
Yes.
In that period of time where there was litigation over the property, did Mr. Redwine ever make a motion for custody over that period of time?
No.
And then he got the windmill home, and there was a motion to relocate. All the properties finalized. Then what did we do?
When there was nothing else to litigate over property-wise, then Mr. Redwine all of a sudden wanted to be the primary custodial parent and used the fact that Ms. Hall had to travel for work, wherein Dylan had to go with her and therefore miss school, as a basis to award him primary custodial care for Dylan.
And he did this after years of not bothering the visit.
Correct.
Objection, leading.
All right.
I'll withdraw the question.
Answer's already out.
Objection.
Anything else?
No, Your Honor. Thank you.
Any questions from the jury? Can this witness be excused?
Yes, Your Honor.
Mr. Moran? Thank you, Ms. Harrison. Thanks for coming back. Next witness.
Thank you, Your Honor. The people called Kathi Berry.
Ms. Berry? I'm sorry, I wasn't watching. I was thinking about something else. I wasn't watching. Up to the witness, stand up here, please. And if I can have you raise your right hand. No, hold here. Like on TV, yeah. Raise your right hand.
I don't know what I'm doing. I'm sorry.
That's all right. Do you solemnly swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Have a seat. Speak into this microphone.
Good morning, Ms. Berry.
Good morning.
Could you please start by introducing yourself by your full name to the jury?
Yes, my name is Kathi Louise Berry,
And could you please spell your last name for the court reporter?
B-A-R-R-Y. It is Kathi, K-A-T-H-I.
And Ms. Berry, where are you from?
Where am I from? I was born in Utah, raised in Wyoming, and have lived in Colorado since I was, 2018, something like that. So mostly Denver.
Okay. And have you always lived in Denver, that part of Colorado?
Yes.
Is that Evergreen? Is that considered Denver?
Evergreen is 30 miles west of Denver in the foothills.
Okay.
And yes, I've lived there for 25 years.
What do you do for work?
I'm a mortgage broker.
Okay. Do you know Elaine Hall?
Yes.
How do you know her?
I met Elaine on one of the searches for Dylan.
How did you become involved in the searches for Dylan?
I saw Elaine's picture come across my news feed on Facebook one day, and she was standing on a dam, and she just looked really sad, and so I just wanted to help her.
And when you were trying to help her, did you get involved at the stage where Dylan was a missing child, or did you get involved after his remains had been found?
Missing.
So why did you get involved? What was the purpose?
Why did I get, because I wanted to help find, I just wanted to help find him.
And at that point, was it known what had happened to him?
No.
Did you also know someone named Denise Hess?
Yes.
She a friend of yours?
She was.
How did you meet her?
I met Denise Hess on the night I arrived here to do the search the next day. She helped me. I reached out to the Find Missing Dylan Redwine page, and she messaged me and helped me find a place to stay. And that's how I met Denise Hess.
And then did you become friends with her after that in the context of searching for Dylan?
Yes.
Is she still alive, or is she deceased now?
She's deceased.
How did she pass?
She passed away of colon cancer.
Do you know Mark Redwine?
No.
Do you know what he looks like?
Yes.
Is he here in this courtroom?
He is.
Can you please indicate where he's sitting and something that he's wearing for the record?
He's sitting right there, and he's wearing a gray jacket.
Does the record reflect that the witness is indicating the defendant?
Well, there's a couple gray jackets here. Yep.
He's got glasses on. He's looking at me.
All right, I think that's close enough.
Thank you. So you don't know him personally, correct?
I do not.
Have you had an incident where you met him before, however?
Yes. Sort of, I guess.
Is
Okay.
this the incident that I need to do the limiting instruction?
Yes, Your Honor, and this would be a good time. Thank you.
Ow.
Okay. Ladies and gentlemen, the evidence you're about to hear about is admitted for a limited purpose. The evidence is not being admitted to prove the defendant had a bad moral character, and the jury cannot use this evidence for that purpose. This evidence is being admitted in an attempt for the prosecution to prove that the defendant became violently enraged when confronted by others concerning his sexual preferences. They can be used by the jury for these purposes and no other.
Thank you, Your Honor. And as we approach that incident, Ms. Berry, so how long were you involved in the search for Dylan while he was still a missing child?
Well, I came for the search. I came for the gathering in February of 2013. At this point, we didn't really know for sure what had happened. And then up until they found his remains, I guess, he was a missing.
While he was still a missing child.
Okay. Really quick. I think it's so funny. Let me put me up here. Hold on. Where am I at? I think it's absolutely hilarious how they've had to say more stipulations and, regarding these photos and his sexual preference, etc. I mean, way more people are being told about this than ever would have needed to. So if that was the motivation and his motive behind killing Dylan, like, you really made sure that your sexuality and your preferences were out in the open for everybody to hear by doing this to Dylan. You would have thought that, maybe you'd have gave him some hush money or something. I don't know. Crazy.
Person.
So from February to roughly late June?
Correct.
And were you interacting with Denise Hess, Elaine Hall, and that group of people who are interested in finding Dylan?
Mostly Denise Hess.
Okay. And then what happened? Was there an instance when Dylan's remains were found and a lot of people were very upset?
Yes.
Can you just explain how you became aware that Dylan's remains were found?
I was here in Durango, or I was in Bayfield at the time, and I remember somebody saying that they had found a shoe or something. I mean, we knew at that point that I'm trying to think if it's hard to remember the exact date, but they had confirmed that Dylan's remains were found that day. That was the day. And that was the day that Elaine received a text message from Mark that said that he hoped her and her colon cancer riddled BFF died and that she died too. That's what he said.
Object out here, sir.
You need to object just a little sooner before it gets out. Do you have a response to the hearsay objection?
I mean, So the answer is, Judge, that it informed what they did next, and that's the reason that's relevant.
The objection is, I didn't want to give you a reason. That's your job, so overruled.
So that text message you referenced, did that upset people?
That's why we went there, yes.
Were people also upset generally? Like, was this a difficult time?
It was probably one of the worst days, I think, ever.
So how close in time was this to finding the remains, that this whole interaction we're talking about?
I think it was the same. I mean, I know they announced the remains that day, that for sure they were Dylan, but that was not the day they found them. I believe it was earlier than that.
So everyone was upset about the remains as well? Both topics, I guess.
Yes, absolutely. Mm-hmm.
So then did Denise Hess and did you decide to go somewhere?
Denise wanted to confront Mark about the text message. She wanted to go over there. She had been talking about it for a couple of hours. She was enraged and wanted to go confront Mark about the text. Okay. And so everybody pretty much calmed her down. She wasn't going to go, but then she was going.
Okay. Was there also, and we'll get to this when you got there, but was there also discussions leading up just about the idea of confronting the defendant about Dylan as well?
I don't recall that, no. I mean, it was more just, I want to talk, she was really angry about she knew Mark and she was upset about the text.
Understood. So what did you do at that point?
I told her that
Okay, I want to pause it just for another quick second. Okay, so facing reality, right? Like, think about that, okay? You are, a spectator, so to speak, in this event, right? You're not a real full-time player. You don't have really anything in this. You're trying to help a mom find her son who's missing, right? You have cancer. You're on your, last kind of legs. You're spending your time, your energy, your effort to go look for this missing child. And the father of said missing child, who looks like was the last person to have seen him, whose remains were just found behind your home, you have the time, energy, and effort to be like, I hope you die. You and your colon cancer BFF, die. Does that... Judge, can we get a stipulation that says to the jury, you can absolutely use that situation to judge the moral compass of this defendant? I mean, seriously, he's not out there looking for his kid. He's not showing any kind of signs of empathy or care or, reverence or anything for the situation, for his child. It just screams guilty. It really does. Ugh.
I would drive her over there if she wouldn't go alone, because she was going to go alone.
Did you, in fact, drive over there?
I did.
And where was over there?
Around from where I was pretty close to the lake over on Mushroom Lane. And so we just basically drove down the road and took a right and drove down the road. And we passed and then a dead end. So we flipped back and came back. And that's when he was standing there.
Is this the Mark Redwine's home in Bayfield at 2343 County Road 500 up north of the lake?
Yes.
When you drove over there and you flipped around, then where'd you go?
We were driving back, and Mark was standing at the door. I think he was standing there in his underwear, and he asked, Kat said, stop. So I stopped.
Kat.
Oh, I'm sorry, Denise Hess. I call her Kat. So we stopped. And do you want me to continue about?
So where did you stop?
We stopped right in front of his house on the road.
Did you ever go on his property?
No.
Did you ever get out of the vehicle?
No.
And when you stopped out front, he was already at the doorway?
Yeah.
What did you do then?
I was pretty freaked out. I was just kind of sitting there. Kat was doing most of the talking. Denise was doing most of the talking to Mark. They were yelling back and forth.
Okay. What was she yelling at him about?
It started out, she said, hey, Mark, why don't you come outside? And he said, fuck you, why don't you come over here? And then she said, I'm not coming on your property. And he laughed at her and said, come on. And so he called her the C word. I think she called him a few names. They interacted for a couple minutes.
Did it remain verbal?
Yes.
At some point, did she say something about not letting him forget what he'd done to Dylan?
She did.
And then, Go ahead.
She did. She said, because he had said something to her about dying of cancer, something about the last breath, and he was laughing. And she said, yeah, well, you know, it will be my last breath, and I will make you pay for what you did to Dylan, or I can't remember, but it was in reference to that.
So in even saying what he did to Dylan, did it stay verbal all that time? At some point, did you speak up and yell something at him too?
Okay, pause, hang on. And really quick, again, this, like I said, this shows where his brain was, how he was. So if he's willing to have a conversation and scream and yell to this stranger, imagine how he treated Elaine, right? Imagine those emails back and forth that her and Corey got up in the court in the advisement hearing to say, hey, like he's threatening, he's etc. Like, yeah, he's not a good person, man.
I did. So I was pretty quiet. Didn't actually through the whole thing. I said nothing, and I was tapping her like, let's go. I was kind of afraid of him anyway. But they kept talking, and when he said something about that he would dance or something when she was dead, and he was laughing. I remember him laughing.
What did you say to him?
I'm telling you, I literally lost my mind. I flew over the seat. I was almost on top of Denise. I took my seatbelt off first. I flew over the seat. I had my head out the window, and I called him a shit-eating, motherfucking piece of shit-eating asshole. I really went on and on. I think I probably said it 10 times.
Let me stop you. Did you specifically, you just said shit-eating?
Yes.
Were you specifically referring to photographs yelling at him, calling him a shit-eater?
Yes.
Did his response change from a verbal argument where he was laughing and cursing
Yes.
to something different at that point in time?
Yes.
Please explain that to the jury.
So he had come out the door at one point. Kat was telling him to come out. He was telling her to come on his property. And he was standing kind of by the driveway. And that's when, he was kind of coming towards my car. And
Oh, she said, you shit-eating. I'm sorry. Let me get composed. Face reality, Mark. You shit-eating. Ooh, that's funny.
And I was screaming. And then all of a sudden he picked up this log off this, it was like a stove or something in the yard. I can't remember what it was, like an oven or something. And he picked up that log, and he can like this. And all I remember was, I don't know if you've ever seen the cartoon where the eyes bulge out and all you can see is the white of the eyes, but that's all I saw. And it scared the shit out of me. And I just said, let's go. And Kat was saying something else. And then I said, eat more shit. And I hit the gas and I went.
Did he come towards the vehicle?
He stopped at one point, but he was pretty damn close.
So he had been, you described, at a location at the doorway.
Yes.
And then a location at the
It was closer up by the driveway he was at the edge of that driveway.
Came out to the.
Yes, but he didn't leave his property.
And then why did you speed off?
Well, I didn't want him to hit my car with the log or Kat.
Were you scared that might happen?
I was absolutely convinced it was going to happen if I didn't go. Yeah.
That he was either going to hit the car or hit Kat because she was closer. She was on that passenger side.
Yes.
Thank you, Ms. Berry.
You're welcome.
So, Ms. Berry, I don't mind you using cuss words when you're describing what happened, if those were the words that were used, but in terms of what happened at that house, but when you're describing your reactions, please maintain a little decorum.
Absolutely.
All right, Mr. Moran.
Your Honor, I know it's a few minutes early, but I have something I'd have Ms. Berry review that may save time if we do it now. Of course, whatever Your Honor's pleasure.
Well, I don't care. I mean, whatever you think is the fastest way to get through it is what I want you to do.
I think that it would make sense to have her review it over the lunch break, and then we can do the gist.
Okay, and what are you asking her to review?
A transcript of her one and only description of this interaction she just described.
All right.
Pause. I was wondering if he was going to say something because, yeah, she can't just be up there cussing, but she can reference what, what is being said. There's another court case that I'd like to go through with you guys, and it has some very interesting text messages that have to be read out in court. And yeah, I'm too childish, and I laugh at things, so it would be hard to keep my composure in the courtroom. Kind of same as this. Oh.
You have any problem doing that, Ms. Berry?
No.
Okay. What we'll do then is we'll take our lunch break. Remember my admonitions about not talking to anybody. Don't let anybody talk to you. Don't do any research on this case. We will start up again then at 1:15. So thank you very much. Everybody rise for the jury. Rise for the jury, please, instead of talking in the courtroom when we're on the record. And then at 1:15.
All right, give me just a second and we'll get on to the next. They're taking lunch break. Oh, can't be talking in the courtroom when they're on the record. We knew that. All right, give me just a second and we'll get on to the next. They're taking lunch break. One of the great benefits about watching this together on our own time is that we can do this. We can skip ahead. We can. All right, give me just a second. We'll get on to the next. They're taking lunch break. They seem to be out of order. About watching this together on our own time is that we can do this. We can skip ahead. We can. Well, okay, we're gonna play it. This shows us where it finishes, but I don't think we had Kathi finish. But here we go. Here we go.
How close was it? Was it close in inches, feet? I mean, how far off was it?
I would say inches.
Okay. The wear marks on the back of the couches make it look like they were up against the back wall. So what was the point if it's not a real reconstruction? Can you answer that?
I can't. I mean, if the couches were moved, marks on the back of the couches, I'm not sure what they could be.
Okay. Anything else from either side?
Yes, Your Honor. So, Investigator Cowling, perhaps I didn't ask the right questions going into this, but are there going to be issues later in the case where the jury, it may be relevant to them, the size of the living room in general?
I don't think so.
Let me ask a different question.
Yeah.
In the investigation, was it a relevant fact to you, given some of the things you're investigating, the size of the living room?
Asked and answered.
No, it's a different question.
So let me ask the question, and let me try to ask a good question. Okay. In terms of the size of the living room during your investigation, having been in that room, was the size of that room relevant to some things in the investigation?
Yes.
And these types of things that it was relevant to, are they things that are down to 1 inch or 2 inch?
Okay, pause real quick. I'm gonna assume they had camera issues or difficulties or were not able, for whatever reason, to finish filming Kathi. This is supposed to be Joe Clayton, I believe. Yeah, sorry that just kind of skipped like it did, but let's get through it.
Or are they just things that it was helpful to be in the room and see the size of it for?
Your Honor, if I may, with the limited scope of what this witness has been allowed to testify about and how we have been restricted in what we can ask, this is a really big question. Essentially, is this relevant with respect to an investigation that spanned a long time? So we object unless the court wants to extend the scope of this witness right now.
We're not going to extend the scope of the witness, but this is relevant to this actual proceeding in terms of what the jury just saw and whether or not the fact that it's an approximation or not an approximation is important to them. So go ahead, Mr. Johnson.
Thank you, Your Honor. So, Investigator Cowling, let me try to ask this and stay right on the point that we're making, right? Have you ever heard that football is a game of inches?
Yes.
Whether you cross the goal line can be an inch or not an inch?
Correct.
But for the purposes of what we're talking about in the living room, your investigation didn't have questions that hinged on 1 inch. Was it more the room itself, like getting a feeling for what the room looked like?
Correct.
That said, you got out a tape measure and reconstructed that from the pictures and measurements that you had accurately.
Yes.
But whether they were pushed up exactly against the back of the wall, that's not the purpose for the reconstruction, is it?
That's not the purpose, no.
Okay. Did you find it helpful as you investigated this case to have
I'm
been...
going to stop there.
Okay, understood, Your Honor.
Do you have anything based solely on that?
Is that room big enough to throw a football in?
It's a fairly small room.
The question is, could a ball travel through the air in that room, or is it so small that a ball could not be thrown?
It's possible.
Or, the way that it was reconstructed, you mentioned on third redirect that it was inches, not feet. You believe the approximation, but you don't know with respect to how far the coffee table is from the couch was to the TV stand. We could be talking about feet because you never took those measurements, right?
I don't believe so.
So you have faith enough in your approximation that you don't think that you're off by 12 or more inches on any of the things in that room?
I believe it's accurate.
You're guessing, right?
No.
But you're not basing it on measurements taken.
Right.
That's it, thanks.
Okay. Now you can step down. Thank you very much. You're good to go, Mr. Kelly. How long is direct on your next witness?
Certainly more than a half hour, Your Honor. That's what are you thinking?
Well, I'm just wondering if we should take a break or not. Do you guys want to go for 20, 30 minutes, or do you want to take a break now? Keep going? All right. I'll break around 3, maybe a little bit before. Okay?
Thank you, Your Honor. The people call Joe Clayton.
All right. Come on up, Mr. Clayton, up to the witness stand. Just over here. And then raise your right hand for a second. Do you solemnly swear or affirm and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes, I do. Thank you. Have a seat.
Okay, here's Joe Clayton.
Good afternoon, sir.
Hi,
Could you please start by stating your full name and introducing yourself to the jury?
my name is Joe Clayton, C-L-A-Y-T-O-N.
And Mr. Clayton, how are you employed?
I am retired, thankfully.
And how were you previously employed?
I was an agent with the Colorado Bureau of Investigation and also with the Kansas Bureau of Investigation.
Should I refer to you now that you're retired as Mr. Clayton, or is there another way I should refer to you?
That's fine.
Okay. So, Mr. Clayton, I want to ask you if you were involved in a search warrant back on November 9th of 2012.
Yes, I was.
And back then, where were you employed at that time?
At the Colorado Bureau of Investigation, or the CBI lab in Grand Junction.
And what was your job then?
I believe I was an Agent 2.
Is that a title within the lab?
Correct.
Okay. And what is in, well, let me back up. In Agent 2, what does an Agent 2 do?
There are numerous sections of the laboratory that you can work in. There's also investigations, but I was on the laboratory side. And Agent 2 is just a ranking of those agents. I worked in blood and body fluids, serology, and I also did crime scenes for the state.
Does that involve crime scene processing?
Yes, it does.
Now, what kind of education goes into that career of crime scene processing?
Well, I have to say this is not like you would see on TV. So I have a bachelor's degree in biology, a minor in chemistry and in behavioral sciences. I have attended a lot of specialized training in crime scene reconstruction, homicide investigation, a lot of blood spatter interpretation, anything along the lines that would be handy at a crime scene.
And what year did you enter the field generally of crime scene investigation and lab work?
1991.
And you had mentioned 2 places you've been employed. Where were you employed in 1991?
At the Kansas Bureau of Investigation main laboratory in Topeka, Kansas.
And how long were you employed at the Kansas Bureau of Investigation?
3 years.
What type of work did you do there?
Again, I started off in the biology section doing blood. I was trained in hair and fiber analysis, but mainly doing blood and body fluids.
Okay. Is that what serology is?
Correction, yeah.
And what was can you describe the other roles that you had, like the work that you did?
Whoever got that phone on, turn it off. Go ahead.
I'm sorry, I didn't.
Yes, Mr. Clayton. So you talked about serology is the analysis of blood and bodily fluids, correct?
Correct.
And then you talked about other work that you did in terms of crime scene work. Was that at Kansas Bureau of Investigation or at the Colorado Bureau of Investigation?
In both states.
So what other work did you do in crime scene investigation in the Kansas Bureau of Investigation?
I responded with another crime scene responder, and we would go and investigate whatever kind of scene we had.
Are these crime scenes?
Yes.
And did you work in the Kansas Bureau of Investigation with law enforcement?
Yes.
So what is the Kansas Bureau of Investigation?
Most states have a bureau like this. It's just a state level. If there's a situation like on a county line, I have jurisdiction in that state. So counties, I don't have to adhere to one county or another county. I can travel freely throughout the state and have jurisdiction.
Is that similar with the Colorado Bureau of Investigation?
Yes, it is.
When did you start there?
1994,
And then just to bookend it, when did you retire?
2015.
Did you spend the entire time from 1994 to 2015 at the Colorado Bureau of Investigation?
Yes, I did.
Did you have various roles there?
I did.
Can you talk to the jury a little bit about the roles that you had working for the Colorado Bureau of Investigation?
I was an agent when I hired on. I got promoted to an agent 2. I then got promoted to an agent in charge of a group called InstaCheck. And if you buy a handgun in Colorado, we're the ones that would do the background check on that. I did that for a few years, but really didn't like it. So I took another job out in Grand Junction as agent in charge over the entire laboratory. And then I still missed my field work, so I took a voluntary demotion back down to an agent 2 so I could do the crime scenes full time.
And what do you mean by field work and doing the crime scenes full time?
Field work to me is going out, responding to a crime scene. An agency calls and says, we've had something happen. Maybe an officer-involved shooting. It may be, a murder-suicide. You just don't really know. And then it would be my job to go out to that scene and determine if we had enough people, if we had enough product, whatever we needed to do, and respond to those full time.
So are these what you might refer to as fresh crime scenes?
Not always. Sometimes they were discovered after the fact. We might have a body that has been found, for instance. So typically more fresh than aged.
Okay. So, for example, would you respond to scenes where there had been a shooting?
Frequently.
Okay. Or a stabbing or something like that?
Yes.
Did you also respond to scenes where it was unknown what had happened?
That's correct. We usually go as a death investigation, so I don't have that mindset of a suicide or as a murder. I'm just going to see what the facts tell me.
And then in addition to that, you ever go out to places that were related to missing persons?
I did.
In what context would you do that?
Typically, somebody is missing. The local officers are just asking for assistance. So we, as a bureau, can send out investigators and lab people, both, to assist them in seeing what we can determine.
And at times where you have to ask to discover, for example, if foul play was at hand?
We're frequently looking for that, yes.
So when you talk about processing crime scenes, what types of methods would you routinely use to process crime scenes?
As part of the 7th generation at Jones Dairy Farm, being part of the leadership.
Well, it kind of depends. If you have one decedent inside a motel room, or if you have a scene that maybe is miles long, it would determine, you just have to take an assessment of what you think you have going on here. And that may take a few minutes. We call it an initial walkthrough, just to assess, do I have enough people? Do I have enough product? Do I need more personnel? Are there dangers present? If there's gas leaking, or if it's in water, something like that, it could be dangerous. And then you come up with a plan. Basically, if I was referred to as a primary crime scene responder, and there were just 3 of them in Colorado. I would go out and lead the investigation, but I might determine that I want somebody else to take the photographs while I do the blood collection. So as a primary, I come up with a plan, and that just was tailored to what kind of evidence I'm trying to recover, how much of it I'm trying to recover, and where it is.
So, Mr. Clayton, you talked about a few things there that I just want to break down a little bit. You talked about taking photographs on the crime scene.
Correct.
Is that one form of evidence collection that occurs in the process of crime scene?
Yes, we have to photograph things as we find them. EMS and fire departments have a job to do, so the scene may be disturbed already by their efforts to contain something. That's not unusual at all. I had a rather extensive photography schools that I had attended, 2 weeks at the FBI, just taking photographs, and I was the primary photographer for the state for a number of years, for Colorado.
Okay. And with regard to, I think you also talked about actual physical evidence collection?
Correct.
Is that a part of crime scene analysis as well?
Very much so, yes.
Can you talk to the jury about that?
I'm just going to use one of these bottles as an example. If I want fingerprints off that, The top of it has ridges where I probably can't find a fingerprint, so I'd pick that up. I'd be gloved, of course. I'd pick it up and put it in a paper bag, so it could be sealed properly, sent to the laboratory, and then it could be processed at the laboratory. I don't do very much processing at the scene. All I'm trying to do is secure and collect the evidence so it can be tested at the lab at a later date.
And with regard to evidence collection, you gave an example of taking an item that might be processed later. Do you also work in crime scene investigation to collect trace evidence?
I do, yes.
And can you explain that a little bit to the jury?
Well, it sounds kind of simple, but the lint roller is your friend in crime scenes. I'm trying to get the top layer, typically. So if I think there's been a tussle, I may take that lint roller and just roll it over, or my jacket, just roll it over and collect that. Take it, put that in plastic, hold it to itself. Not the sticky part to itself, but fold it to itself and then put it in plastic so it can go to the hair and fiber trace unit to be examined at a later date.
And how about blood evidence?
Frequently encountered at crime scenes, and there's a number of ways to collect that. We chose to use sterile water and cotton swabs, typically, and I would take the 6-inch long sterile cotton swabs, open the package, moist the swabs, if typically the blood is dried by that time, and then swab that up and put them back in the paper, the swabs back in the paper, bag they come in, and then put that in a protective envelope and get it ready to send to the lab.
When you talk about trace evidence and blood evidence and collecting that, is that something that you're looking to later perhaps do DNA testing on?
Frequently, we would do DNA. When that became a viable test, we would do DNA on it.
Okay. So if there's visible blood, do you collect it by the method that you just explained?
I would.
And then if there's not visible blood, are there other methods that you've used in the crime scenes you've processed over the years to look for the blood?
Yes, there are.
And so can you explain just a little bit about that to the jury?
There are several compounds known. What we chose to use at the CBI when I wrote the protocol is called luminol, and it glows blue when you apply it to a blood stain. You have to have darkness to see it. You don't want interfering light, and it has a very distinct way of glowing and then diminishing as the luminol wears off. It's water-based, so if you can't see the blood stain, you don't want to just be pouring luminol on it. You want to use it very sparingly. You want just a mist to come out and settle gradually. You don't want to blow your stain away. So there's a number of chemicals out there. I believe it was called Blue Star was another one, and I was working with that company on their protocol. That product was used, I think, intended for hunters. If they wounded a deer or something, they could take basically the same chemical I'm using, luminol, and take it out and try and track their prey. You don't want interfering light.
Okay, real quick, pause. So he's speaking about the luminol, and you can tell behind him is where that television screen is. That's where they will end up showing evidence. It will be hard to see unless he moves his body in his position. But linked in the comments below, I have a list to the prosecutors and the defense's exhibits, their evidence. And so you'll be able to see the pictures of where the luminol was sprayed. On the coffee table, on the sofa, on another area of a couch, on the floor. To me, the fact that there was really kind of any shown up like that, because, if you've bled that much, you've probably went to the hospital, to the doctor or something. So I don't know, just my opinion.
Great.
And so you mentioned designing or putting together the protocols for Colorado Bureau of Investigation. Can you explain to the jury the process you used to do that?
Since this other product had come out, this Blue Star, I wanted to check it, how effective it was, as opposed to the product I was using which was luminol. I compared and contrasted, if you will, those two chemicals, talking with a company about what their product contained, because that's kind of important. I don't want something that will degrade the DNA. And talked to them, then wrote a protocol and decided on using luminol that we made in the laboratory. You can purchase the product, but you have to mix it with water and another chemical. But I just decided on a protocol, and I thought, after all my testing and research, that it would be better to stay with the luminol than to use a commercially available product.
And so what kind of research did you do into that?
Well, again, I had to know what they had in their product, because I don't want to spray something that is detrimental to the blood state. Blood is relatively fragile, and you can break it down like in sunlight, or if you spray a high acid content or anything that dilutes it. So I just wanted to make sure I was using the best product that the laboratory could have. So I researched out their product in the luminol, and again, just came up with a protocol that I thought worked best for the laboratory here in Colorado. It's dry, and I settled on luminol.
Now, is this, at what point in your career that started in 1991 were you assigned or responsible for designing these types of protocols?
That was when I was here at the CBI in Colorado, so that was after 94.
Okay. And how far into your time here in Colorado? Like what year are we talking about?
Oh, I don't really recall. I'd say probably 10 years.
Okay. So you had 10 years of crime scene experience before you were assigned that?
I had the 3 plus 10, so 13 years at that point.
And throughout the years at CBI, do you repeatedly have trainings in different areas of crime scene investigation?
Colorado Bureau of Investigation has a week-long course that we would go out and teach to local agencies. And I was a primary instructor in that. And that's all areas of crime scene. Investigation.
What other areas did you teach in crime scene investigation?
Firearms, fingerprints, obviously the collection of blood or body fluids, sexual assault kits, hair and fiber, chemistry, which would be drugs, just all areas of the laboratory.
How about blood spatter analysis?
I was a certified analyst in blood spatter for a number of years.
And what does that mean to be a certified analyst in blood spatter?
Our laboratory works under a certification process where you're given tests throughout the year and see if you can answer those. They're designed so you have to answer those correctly. And when you do, then you're state certified or nationally certified in crime scene analysis or blood spatter interpretation or fingerprint identification.
Does the CBI laboratory, that's a government entity?
Correct.
Did they require accreditation of their laboratories?
All of the laboratories had to have accreditation.
And then did they require certifications such as the certification you just described for their employees that go out and do either instructing or processing?
Yes, you had to be certified to do that.
And then also, Mr. Clayton, you talked about luminol. Are there other tests that you would use in the field to see if there was blood present?
I said we don't do DNA or other processing out in the field. So I have a set of chemicals, or a set of tests, that I progressively tighten. I don't identify blood, but I can highly indicate the presence of blood. I will allow the lab to identify something. I will indicate the presence.
So, for example, if you see a red stain and you think it might be blood, are there tests you can apply to see if it's blood?
Yes.
What kind of tests would you apply?
Well, right off, visually, most of us know what a blood stain would look like. I trust my eyes, but I would use a chemical called phenolphthalein. Phenolphthalein is, again, a color-based test. If you swab it and apply the phenolphthalein and another chemical, it will turn pink. But that's just indicating blood. It could be earthworm, it could be mouse, it could be any kind of blood. And I would just progressively test further to tighten that circle, make sure I've got a blood stain.
So I want to walk through this process just a little bit now. But you talked about you can either see a blood stain or you don't, right?
Right.
And if you don't, an option is to apply luminol.
Correct.
Hold on a second. Got something, Mr. Redwine?
Yes, I have an objection. I felt like you're starting to, or the council was starting to certify and endorse this with on an expert on a number of topics. And now I feel like it's actually testifying on the topic without that sort of meeting on the question.
But it's not talking about this case. So why can't he do that in terms of the qualification?
That's my point. At this point, given the questions and the answers, as far as the council is concerned, if this is foundation as an expert or if it's testimony as a topic to be working with.
Well,
so
he can.
I'm just asking the foundation you lay before you go further. You want an EPA card, and all that.
This is still the foundation, correct?
Yes, sir.
I don't see anything wrong with this. I mean, he's not talking about what he did in this case yet. It may be some of the same techniques, but I don't see any problem with that. Go ahead.
Thank you, Your Honor. So, Mr. Clayton, just to kind of to hone back in now. So you've applied luminol over years. Is it fair to say in the entire time you've been a crime scene investigator, luminol is one of the tools you've used?
It's available to me, yes.
And is that something that you have seen in person, on crime scenes, know how to interpret, et cetera?
Correct, all of those.
And then you mentioned phenolphthalein. Is that another chemical you're familiar and skilled at using in the field?
Correct.
And then you were talking about hemotrace. Is that the test that determines whether that blood is then human or primate or not?
Hemotrace, or also called an ABA card, is a test that is specific to blood of higher primates. So gorilla, orangutan, I believe there's a lemur in Madagascar that's supposed to have a positive, or human, but it will not react to, say, mouse blood.
So in terms of all of these skills that you've used, how many times have you been out on a crime scene responsible for processing the crime scene?
Unfortunately, when I started in Kansas, we didn't keep an accurate and precise count. I worked it up mathematically the other day, the other year, and it was, I think it came out to 1,007 is what my best estimate my crime scene response has been.
So that's over about 2 decades?
Correct.
And that's been out there employing all these methods that you just explained to the jury?
Correct.
Have you testified as an expert witness before in these areas?
Yes, I have.
What areas have you testified as an expert witness in?
Blood pattern interpretation, crime scene investigation, crime scene processing, serology, photography. Can't think of any others right off.
Okay. Approximately how many times have you testified as an expert witness in a court of law for trial?
Well, again, when I started at Kansas, we didn't keep an accurate and precise count of the number of times I testified. My best estimate is 350 to 400 times.
That you've been qualified by the court as an expert in one of these crime scene investigation or analysis forms?
Correct.
And then specifically, have you testified before as an expert in the processing that involved the use of luminol, phenolphthalein, and I called it Hemotrace, but you called it something else?
It's the same, Hemotrace or Abacard. Hemotrace is a brand.
And the collection of blood evidence in those areas specifically, have you been endorsed as an expert and testified as well?
Since the majority of my cases were crime scene or biology, just about all of them, I would guess.
So, Your Honor, at this time I'd move to qualify Mr. Clayton as an expert in crime scene investigation, including trace evidence collection and interpretation.
Mr. Bogan?
No objection as to endorsing crime scene investigation regarding trace evidence collection. What was the other one?
Interpretation.
And interpretation of that.
No objection.
Okay.
No objection. Not by the mic.
Thank you. He'll be qualified as an expert in crime scene investigation, trace evidence collection, and interpretation.
Thank you, Your Honor. And at this point, we're going to move into an entirely different chapter, and I didn't know if it's a good time to break or if you'd like me to do that. We're going to have exhibits and things like that.
Okay. It's just we started a little early, so I thought we might want to break a little early, too. Let's take 15 minutes now. So.
All right, so we've got our first expert coming in now that he has been, allowed in as an expert. It really kind of takes a while sometimes to get started and get into their testimony in that case that they have to go through all of their experience and how many times and all of their schooling, etc. So we did make it past that. I'm going to go ahead and stop there for the day. Again, this is Joe Clayton. He is retired now, but he was a crime scene investigator. And so we will be able to come back tomorrow and get right into his testimony. If you haven't done so already, please like the stream. Also subscribe, turn on that notification bell. That way, you'll know when I go live again. And I'd love to keep up the conversation about Dylan.